Hello students, hope everyone is doing well and staying healthy. Today what we are going to do in the Intro to Law course is two things. We're going to finish up constitutional law, and in particular we're going to talk about the idea of federalism and national versus state power. And then if we have time, we are going to talk about, at least start, the area of criminal law. So in terms of the readings, as I indicated before, but I want to reiterate, as of right now, you should have finished everything in the constitutional law section and be reading the criminal law section. So Carper chapter 2 should be done, and for criminal law you should have read Carper chapter 6 and Baum chapter 6. And the lecture after this we'll be talking about criminal law in a lot of depth. All right, well, if you remember, the last time I spoke to you, we were talking about constitutional law. And we're talking about the importance of constitutional law. And within that context, what I indicated to you is that there were three major elements of constitutional law: civil liberties, civil rights, and government structure and operation. So we defined for you civil liberties and civil rights. We said civil liberties were freedoms from governmental interference. So these are individual freedoms given to all of our citizens against government intrusion. Things like freedom of speech, freedom of the press, freedom of religion, the right to be secure in one's home, freedom against unreasonable searches and seizures, self-incrimination. And we talked about those things. And then we said civil rights. And we said that civil rights deal with issues of discrimination, and can you treat people differently based upon certain characteristics. So it deals with the issue of inequalities under the law, the denial of privileges to persons because of some characteristic, whether it's gender or race or ethnicity or sexual orientation or religion. And as I indicated, in regard to the area of civil rights, we have a course on discrimination that some of you are taking right now, and in regard to the whole idea of civil liberties, that's the issues that the constitutional law course deals with. Well, the last thing that we said that government does that I want to talk about today, and in particular a specific application, is this whole idea of governmental structure and function. So what we want to talk about in that context is this idea of federalism and constitutional law. And one of the things I've indicated to you is that federalism is one of the most complex concepts that we have in regard to governing. Federalism is this idea of sharing of governing power between national and state government. So we're talking about federalism, the sharing of power between national versus state government. And the question is, how does that work? Most countries that have democracies do not have federalism. They have what's referred to as a unitary form of government, which means that they have a national government that's democratically elected, but then the national government makes the laws for the entire nation so that the law isn't different in different parts of the country. In the United States, we can have different laws, as we see, in regard to, for example, the recreational use of marijuana, those kinds of things. In some states it's legal, in some states it's not. In regard to the idea of guns and whether or not you can carry a gun. In some states you can, in other states you can't. And again, it doesn't matter how this works in terms of, you say, well, in my state I can carry the gun, so now I'm visiting your state, so you can't arrest me for it. The answer to that is, well, that's not true. So federalism is very complex and has a major impact on how we as citizens of the United States enjoy our rights. So when we talk about federalism, the question then becomes, how do we figure out who can do what? How do we figure out this complex relationship between national government and state governments? Who can regulate what? And in regard to that kinds of question, the key features of federalism are, first of all, we have to understand that federalism does not provide for a strict legal hierarchy. So in other words, it's not a situation where you say you have the national government and state government, and then whatever the national government does is supreme in regard to state government. That is not true. There are certain things over which the national government is supreme, and there are certain things over which the state government is supreme, and the national government cannot tell the states to do. So the trick of understanding federalism is to try and understand when the national government can do something and when the state government can do something. Now, within this context, the book talks about this idea of the supremacy clause. The supremacy clause. And all the supremacy clause means in this context is that the national government can dictate to the states only if something is a specific national power. So in other words, if the national government is given a power, then it is supreme within that sphere. So if the national government is given a particular power by the Constitution, then whatever the national government does in that area is supreme over state government actions that might differ. So the national government can, what we use the term is preempt state government actions where it has authority. But again, understand the supremacy clause does not say that the national government is supreme in everything that governments do. There are certain things over which only the state government has authority. So understand what the supremacy clause means. Well, then the question is, okay, how do we know what level of government gets to do what? And does the federal government have to be concerned about passing laws that violate the authority of the states? And do state governments have to be concerned about passing laws that violate the authority of the national government? And the answer to that question, those questions, to both of those questions is yes. National government has to be concerned, and the state government has to be concerned. So again, what we have to figure out is who can do what. So if you're the governor of a state, what are you allowed to do? And you don't have to worry about the national government telling you you can't do it. Or if you're the national government, what are you allowed to do? And we can see this kind of controversy and dynamic right now with the coronavirus. You have state governors imposing their own laws in regard to behavior within their state. So they're telling us we can't leave our homes and it's going to last until April 5th. Well, can a governor do that? And then you had President Trump on television the other day saying, I am at some point going to open up the country and say that there is no more isolation approach. We're going to get rid of this whole idea of social isolation, and I'm going to impose it on the states. Well, can he really do that? Is the President of the United States more powerful than a governor? Or is the governor the most powerful entity within their state? That's the complexity of federalism. And that's why we have to understand how federalism works. Okay. So one of the things that we have to do is we want to understand how federalism works, is we have to understand the powers of national and state government. And in order to understand the powers of national state government, there is one significant legal document that tells us that, and that is The United States Constitution. So the United States Constitution and various parts of it provide us with an understanding of federalism. Now the Constitution, you must understand, does not use the term federalism. But what it does is it talks about the powers of national government, the powers of state government, what they can do, and it also tells us what they can't do. And then it tells us what happens if the particular power is not specified, who gets to do it. So the national government is very specific in telling us about this relationship between national and state governments. And that's important for us to understand. And in particular, when we talk about the Constitution and where it tells us this, we look at first Article 1. Article 1, Section 8 of the United States Constitution, so if you look at your Constitution and read Article 1, Section 8, Article 1, Section 8 tells us what national government powers are, or, to put it another way, what the national government can do. Now, remember, anything that then is enumerated here, the national government can do. So if a state law conflicts with a specific national power, the national law is supreme under the Supremacy Clause. The other kind of qualification you have to understand is this last part of Article 1, Section 8, which says that the national government can make all laws which shall be necessary and proper for carrying into execution the foregoing powers. Now we've talked about this necessary and proper clause. So what this means, as we've seen in the courts, is that the national government can do the enumerated powers, but aside from enumerated powers, it has implied powers. So to the extent that the national government has to do something in order to carry out its enumerated powers, it can do that too. So Article 1, Section 8 are the powers of the national government, what they can or can't do. Article 1, Section 9 tells us what the national government can't do. Article 1, Section 10 tells us what state governments can't do. And then you have the 10th Amendment. And the 10th Amendment becomes incredibly important because it's this general clause that basically specifies that anything, and I'll read it to you specifically instead of paraphrasing it at this point. It says the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively. So in other words, if it's not enumerated or applied in Article 1, Section 8 of the Constitution, then it is a state power. Okay. So using that as a basis, well, we want to start getting a better understanding of exactly how does this play out. Well, in our last discussion about the Constitution, we talked about the impact of the 14th Amendment in regard to national government power. So as a result of the 14th Amendment, we said that the United States Supreme Court can hold laws passed by national and state government invalid if it violates the Constitution. So the question then is, what does the Supreme Court generally turn to and look at in determining whether or not the national versus state government can do something? And we said, if you want to know what the national government can do, you got to look at Article 1, Section 8. But when you talk about this in the context of federalism and the relationship between national versus state government, you want to look at a very specific part of Article 1, Section 8, and that's the Commerce Clause. The Commerce Clause. Because the Commerce Clause really talks about, to a major extent, this relationship between national and state governments. And what it says is it can regulate commerce with foreign nations and among the several states. So the Commerce Clause has been seen as the principal power and authority of the national government, which allows the national government to intervene in issues that relate to the states. Okay. Well, I just read that clause, and generally that clause then legally is defined as providing a distinction between interstate versus intrastate commerce. So interstate are any kinds of activities that cross state boundaries. And again, according to Article 1, Section 8, in that context, a national government or Congress has the power to regulate any activity that deals with interstate commerce. And when we talk about interstate commerce, the other thing we have to understand, it's only the national government that can regulate interstate commerce. But what about intrastate commerce? Well, this is a little more complex, and it's not as definitive. When we talk about intrastate commerce, this is an activity that occurs entirely within a state. And it says if something occurs entirely within the state, then generally the state government gets to regulate it. Okay, well that seems clear enough, but the point is it's a little bit more complex than that. And the other thing that we're going to show is that the Commerce Clause serves two major functions. First, as we said, it is a source of congressional or national authority. But secondly, it acts implicitly as a limitation on state legislative power and action. And when it does this, we talk about it as the Dormant Commerce Clause. The Dormant Commerce Clause. And those are the kinds of things that we're going to talk about. But what I want to do before we get into more of an in-depth analysis of this is to give you examples of this tension between national versus state government. And we'll do this by way of examples. So the first set of examples are, can the national government do these following things? Can the national government impose air pollution standards on every state? So let's assume West Virginia, because of the coal mining industry, is a major part of the economy, wants lower air and water pollution standards so that coal production can go up because it's so important to their local economy. Does the national government have a right to say, you can't do that, here's a standard we want, and you must impose it? Can the national government impose a national drinking age? Saying, you know, there's too many young people who get into car accidents because they're drunk. So what we want to do is make sure that every state goes from 18, minimum purchase age, which is what many states were, to 21. Can it impose that? Can Can the national government pass a law that tells farmers in the state of Ohio they can only grow so much wheat? And if they grow more than that, that's a violation of national law for which they can be fined. Can the national government regulate guns near schools? So as is common knowledge nowadays, there is a lot of gun violence in our schools, our colleges, our high schools, our elementary schools. Can the national government say, we've had enough of this, and we're going to pass a law that says anybody who brings a gun to a school knowingly can be prosecuted and have a mandatory sentence of 5 years? So that's one way of asking this question of federalism. What can the national government do? Well, then the other side of it is, what can the state government do? So, can the state regulate the size of trucks that drive on its highways? And in looking at your readings, they give you some examples about can states regulate certain features of trucks. So you might want to take a look at some point at page 57. And it says, suppose Georgia passes a law requiring the use of contoured rear fender mudguards on trucks and trailers that operate on its highways. All other mudguards would be declared illegal. Okay. Can they do that? Is the Georgia state law constitutional? So it would declare all other mudguards illegal. And it says, according to the book, in 35 other states, including the neighboring states of Florida, straight mudguards are either legal or required. So their requirement can be different than another state's of requirement. Now, Georgia, when asked why they did this, said that there was evidence that suggested that contoured mudguards are safer than straight mudguards. Wow. So what can they do? So can a state government regulate the size or features of trucks that go in their states? Can the state government regulate the dumping of toxic waste in their state? And think about this. If you're a governor or a state legislator, these are the kinds of issues you might have to pass laws about. Can you do it or not? Can the state government pass a criminal law where it says in our state we are going to execute people who are younger than the age of 18 if it is a particularly horrific crime? Or we're going to allow the execution of people who are in very limited mental states. Can the state pass a criminal law that we refer to as the 3 strikes law? In other words, you commit 3 felonies. We use the example of Rumble at the beginning of this semester. You commit 3 felonies, and they might be minor felonies. So for Rumble, I think the total dollar amount of his 3 felonies was like about $240. Well, can you pass a law that doesn't matter? Any 3 felonies you commit then requires that our state put you in jail for life. Now, each one of these examples represents a real case of federalism. A real case. All of these things have occurred. National air pollution standards, national drinking age, the growing of wheat in Ohio, regulating guns near schools, regulating the size of trucks, dumping waste, the execution of minors, 3 strike laws, all of these exist. So these aren't just hypotheticals. These are real life legal issues. And we have to try and get some understanding of how, in our federal system, we decide who can do what. Who can do what? And we said that in this context, the Commerce Clause is a major source of national power and authority, and is generally used as the rationale for national government intervention. Okay, so the Commerce Clause we're saying is incredibly important. The question then is, what is commerce? What is commerce? And we said you can break commerce into interstate versus intrastate. And that clearly interstate commerce is under the sole authority of the national government or the United States Congress. So what is commerce? Well, some of the original cases that the Supreme Court dealt with that helped define this date back a pretty long time. And probably the most famous in this context was the case of Gibbons versus Ogden. And this case was decided in 1824 by John Marshall. And what had happened is Ogden had received a monopoly grant from the New York legislature to operate steamboats from New York to New Jersey. New Jersey didn't like that very much and brought it to court as a violation of the Commerce Clause and national government authority. And it went all the way to the United States Supreme Court, and the United States Supreme Court held that only Congress can legislate with respect to acts of commerce which concerns more states than one. So in other words, if it's interstate commerce, only the national government can regulate it, and this was clearly interstate commerce. At the same time, Marshall recognized that something that was completely internal commerce was reserved for the states. That, again, is intrastate commerce. Okay. So if it's interstate commerce, only the national government can regulate it. If it's intrastate commerce, only state government can regulate it. That's pretty clear. But then the question becomes, how do you define interstate commerce? What is interstate commerce? Is the regulation of air pollution interstate commerce? Is the regulation of a drinking age interstate commerce? Is the regulation of how much wheat you can produce in Ohio interstate commerce? Is the regulation of whether or not you can have a gun near a school interstate commerce? So the courts have attempted to define what we mean by interstate commerce. And probably one of the most controversial cases in this context was Wickard versus Filborn. Wickard versus Filborn. And this case was decided in 1942. Let me give you the facts of this case. The United States federal government and the United States Congress passed what was referred to as the Agriculture Adjustment Act of 1938. And it specified how much of any produce or product a farmer could grow. Now, Filborn was a small Ohio farmer. And what he did is he raised and consumed his own wheat. So in other words, it was only for public consumption, private consumption, he said. But the amount of wheat that he grew and consumed was in excess of the national quota imposed by the Agriculture Adjustment Act of 38. And this act provided for penalties for anyone who exceeded it. So they levied a penalty against Filborn. And again, he argued, wait a minute. I'm growing this wheat wholly for my own consumption. So how in the world can you regulate me? How can you fine me? This does not constitute interstate commerce. And the question is he right or is he wrong? Well, the court, the United States Supreme Court, held he was wrong. They said that individual consumption has a national market effect, and they called it cumulative effect theory. And therefore, given this approach, they say Congress can pass laws that regulate interstate commerce if interstate commerce is affected by it. Wow. Think about that. That is an incredibly broad interpretation of commerce. So what we're saying here is that Filborn's own individual consumption of wheat has a burden on interstate commerce according to the Supreme Court, which allows Congress to regulate his behavior. So this is a very broad definition. And this idea is whether the subject of regulation is for production or consumption or marketing is not material. It can be reached by Congress, even if local, if it exerts a substantial interstate economic effect. Well, another case